Hi everybody, welcome to today's webinar. I'm Matthew Cole and I'm joined by Vanessa Bell, the other partner in the employment team here. Thank you.
Morning everybody.
Thanks for joining us all. What we are going to be doing today is something a bit different for us, something we haven't done for a wee while, which is talk about something other than the Employment Rights Act. Which obviously is making us very excited because variety is the spice of life. And we thought we'd go back to case law. And what we've done is looked at those cases which we think are relevant for HR practitioners. So we have 9 cases at various levels, Employment Appeal Tribunal and upwards. And then we're also going to look briefly at the Equality and Human Rights Commission's recent code of practice on services under the Equality Act, which of course has been highly controversial and affected by the For Women in Scotland Supreme Court judgment last year. So we'll have a quick look at that as well. So we're happy to take questions as we go. If you put them in the chat box, we'll deal with them as we go. Our aim is to be on for about an hour. That's always slightly flexible, as it depends upon how long we decide to witter on for, but also as to how many questions come up, etc. Sorry, I witter on. Vanessa talks far more cogently than a witter.
I wouldn't say that, but you did make me chuckle when you started saying that we witter on.
So we'll start the wittering. What are we going to be looking at today then? As I said, 9 decisions plus the code of practice. We'll try and round up by looking at some themes and putting the various strands together. We can also touch on the ERA if anyone is getting withdrawal symptoms from matters as well, and having an hour off of it, which we probably will, won't we, Vanessa? So. Yeah. Without further ado, I think it's over to you to talk about case number 1.
I think it is. I was thinking 9 is a bit of a random number, really. We should have rounded it up, but there we go.
I must admit, I started with 10.
Right.
And I looked at the 10th, and I thought that's really quite a dull case. So I did it,
okay.
and that's why we ended up with 9.
Well, now you've raised all expectations that all the cases.
Oh yeah, the rest are really exciting.
Yeah, thanks for that.
On.
Yeah.
So,
okay. Right. So I'm going to start with Chowdhury Network Rail, and this is a case about the duty to make reasonable adjustments. So the claimant was a customer service assistant who was employed by Network Rail at London Bridge Station. He suffered from a chronic foot condition. It's got a far fancier medical name than that, but I can't pronounce it, so I'm just going to say chronic foot condition and move swiftly on. And he said that it flared up as soon as he started working for Network Rail. His role was fairly physically demanding because he had to patrol the station and do security checks and provide assistance to customers, etc. When the condition flared up, he was temporarily assigned to an interim help desk duties, but he still remained absent from his role for long periods of time. He was placed on Network Rail's internal redeployment register, and he applied unsuccessfully for a few roles. And eventually, after following their processes, he was dismissed due to his ill health and capability. He claimed that Network Rail failed to make reasonable adjustments. And he said the reasonable adjustments they should have made was redeploying him into one of the alternative roles he'd applied for. And he also claimed it would have been a reasonable adjustment for Network Rail to reassign him into a permanent help desk position and bump one of his colleagues to get that position. And he also said that a reasonable adjustment would have been to have given him more time to secure a new role within the organisation. He also claimed he claimed discrimination arising from disability. He says he was treated less favourably because of something arising from his chronic foot condition. So the claim went to the tribunal. They rejected the claim for reasonable adjustment. They found that the claimant didn't have the necessary skill set, in particular IT skills, for the alternative roles he applied for. And the redeployment policy of Network Rail didn't require them to waive these core requirements for the roles. And they also found that Network Rail had acted reasonably when dismissing the claimant, rather than needing to allow him further time to secure a new role. In terms of the discrimination arising from disability claim, the tribunal held it was a proportionate response to a legitimate aim to dismiss him, and the legitimate aim they agreed with was the one that Network Rail put forward, which was to ensure staff could perform roles and attend work. The claimant appealed, and in particular, he argued that the tribunal should have found it was unreasonable for the employer to consider some of the criteria for each of the potential redeployment roles essential. So it went to the EAT, and they were very much of the view that the tribunal was entitled to find that the claimant didn't have the experience required for the roles, and they were right to take this into account when assessing whether a move into that role would have been a reasonable adjustment. So this is a nice reassuring case to start with, which is always good. And it does give us some comfort that it isn't necessarily the case that we need to, redeploy disabled employees into roles where they don't meet the essential criteria. So reasonable adjustments don't override core job requirements. But of course, each case should always be assessed on its own facts. And they did take into consideration that he had been absent for a long time, and also actually, although he'd applied for a few jobs, there was limited engagement by him in the redeployment process. As a practical note, I think what kind of helped save the employer with this as well is that they did document their decision-making processes with regards to the redeployment opportunities, and so we should always kind of document what our considerations are and how we reach those decisions. And they had clearly documented its efforts to support his redeployment, which was key to their defence. And of course, if an employee asked to be redeployed and you're considering a role, do document why the employee doesn't meet the essential criteria for the role and why that criteria is essential. So it's just a reminder to kind of document your decision-making process and all the efforts you make in such circumstances. That's a nice, relatively straightforward, good news story to start with, isn't it?
It is. We have a question, I think, relating to that redeployment issue on.
No, we just got a question. Have we? We've got a question say, will we get copies of the slides?
We've got one which is, will we get the copies of the slides? And I'm sure we can sort that.
Yeah.
But we have a question on the substance, which is, should the employer bump another employee had a role met his skills?
No. The tribunal did also find that there isn't a requirement to bump another employee.
Yeah.
Which makes sense.
I think it's bumping, particularly in this context, is something which would only be done in absolute extremis. I can't think of how it would be done in a disability case unless there was another job for the bumpee to go into, which was effectively the same, and it was the only course open to the employer. But I really can't see bumping having a role here.
I think that'd be a step too far, personally. I think. Yeah. Okay.
So we'll go to another case on discrimination, this time race discrimination. And this one is concerned with the burden of proof, and it's something we've talked about over the years because it's been a live issue over the years, which is effectively there is a general acceptance that discrimination is often hidden. It's not overt. You don't often find documents which support discrimination. There's not really a smoking gun. So tribunals are going to have to look at other factors. And effectively, we're in a situation where if an individual can demonstrate a difference of treatment between them and either an actual or hypothetical comparator, and then if they can find facts from which discrimination can be inferred, then the burden of proof switches to the employer, and it's for the employer to show that even though the facts might suggest discrimination, there is an alternative explanation. So the burden of proof to demonstrate that there was no discrimination is on them, and that's a very difficult burden to satisfy. And one of the issues has always been that line between ineptitude and discrimination. I may have screwed up, but I didn't screw up because there is any kind of malign intention on my part. I just screwed up because, well, I screwed up. And that's what this case deals with. When is a screw up, and when is it a sign of discrimination? So what do we have? We had Mr. Sadola, who was employed by, or is employed by, the London Ambulance Service now. He initially joined them and worked as a call handler on the 111 service back in 2013. And over the course of a few years, he tried to apply for promotion. And in particular, in April 2020, he applied for a job as a team manager. It's the fourth time he'd applied for that particular position. He wasn't successful, and he claimed two types of race discrimination. First, he said that he was unsuccessful in his application for that job because of his race. And secondly, he said that the respondent had failed to provide prompt, written, detailed feedback on his interview, and that was a claim of a separate act of race discrimination as well. Now, the employment tribunal judgment on this is a bit weird, because effectively they said there was no unlawful discrimination by rejecting him for the job. They said that was purely based upon the scores he achieved for that job, but there was discrimination with regards to the failure to give prompt feedback, and then the nature of the feedback itself, which was very vague. So it's a rather odd one from the tribunal's point of view, but hey, we're used to odd tribunal judgments. Worthwhile just looking at a few more of the facts here. So there were 6 candidates interviewed for the role, and out of those 6, 4 were appointed. Of the 4 appointed, all 4 were white, and scored higher than Mr. Sadola. He scored 7 out of 15. The others scored 9, 10, 13, and 14 out of 15. The feedback he received initially when they called him to say you haven't been successful is, you're a strong candidate, but other candidates are more qualified and experienced. So immediately after receiving that call, he requested written feedback, and there was as part of the policy in place within the ambulance service, there was an entitlement to receive written feedback. He received a very brief reply saying that once all the feedback had been collated, they would get back to him and organise a meeting and talk to him about it. He didn't hear anything for a while, so he contacted them again. They said there were 2 people that interviewed him, and he contacted one of those people who said, well, the notes have been locked away. It's my colleague who's got access to the cupboard with the notes in it. So she's off on leave. So when we get back, we'll get back to you. A couple of months later, they eventually got back to him and gave him some brief written feedback. The feedback was, you come across as very confident. However, you did not answer the questions effectively. And I recommend that you attend a workshop for interviewees. That was it. Now, by then, Mr. Sadola had made a grievance about this. He said that he was expressing the dissatisfaction felt by many Black and minority ethnic members of staff as to recruitment within the London Ambulance Service, and he thought this should be investigated further. We don't really need to be concerned about the outcome of that. What the issue is, however, is that he did not receive good feedback, and there was a significant delay. So it went to the Employment Tribunal, and the Employment Tribunal looked at this, and they said, well, there was a delay. We believe that the claimant may have been treated differently than a hypothetical white comparator who had applied for a job and been rejected for it. The delay itself was poor practice, and in particular, that poor practice was compounded by the fact that the respondent knew that Mr. Sadola was a Black man who had applied for jobs before, had not got the job, which had been given to some white applicants. He had raised issues about the fact that there may be a racial dimension to this, and by not providing feedback, they breached their own policies. As such, there was an inference of discrimination, and it was for the respondent to explain why there was not a discriminatory aspect to the delay and the vagueness of the feedback, and the respondent couldn't provide that, so there was a finding of race discrimination. London Ambulance Service appealed. London Ambulance Service looked at it and said, well, what do we have here? We do have a racial element to this. We have a claimant who has raised issues of race discrimination in the context of recruitment, and we do have poor practice in terms of the feedback provided. But actually, when we look at this, there is not enough there to say that there is a connection between and they called it lamentable practice by the respondent in terms of how they had responded to the request for feedback, and discrimination itself. That nexus didn't exist. It wasn't close enough to be able to say that there was actually discrimination there, and effectively the tribunal had got the wrong test. So this, as with the previous cases, is a case which is slightly comforting for employers, because there has always been this idea that if you have not followed your policies and procedures, if you have acted in a way which is in breach of good practice, then that does expose you to a discrimination claim. It does expose you to an inference of discrimination being drawn, which you then have to rebut, and that rebuttal is very difficult, not just with regards to recruitment, but with regards to selection on redundancy or anything else. What this case is saying is, let's be sensible about this. There's got to be quite a close nexus between the two. So the employer, I think, in this case was let off the hook in the face of an employee who was asserting discrimination and who was subjected to a very poor process by London Ambulance Service, but not enough to be discrimination. Does that mean that we can play fast and loose with our policies and not worry about discrimination? No, not at all. Because arguably, had the feedback been given promptly, had it been given in detail, and had it been given in terms of policies, then that issue would never have come before the tribunal as a claim anyway. And it's half the battle is sort of thinking about how you're going to defend these things, how you're actually going to make sure that they are put properly before a tribunal. That's where the cost is, that's where the stress is. So basically, follow your processes. If you follow your processes, you're in a better position. You don't allow claimants to open up potential arguments like this. So yeah, follow your processes. Vanessa, I think over to you.
Well, yeah, let's continue the theme of follow your processes, shall we? Especially with senior employees. Look at how seamless that was. So the next case relates to the company Zen Internet and the employee called Stobart. So Mr. Stobart was employed as chief executive of Zen Internet. He was initially recruited as a chairman and a mentor to somebody senior within the organisation, the company's founder actually, and the original CEO. And they subsequently agreed that actually they'd switch and Mr. Stobart would become the chief executive. And the expectations of him were very high, as you'd expect of a chief executive, for him to drive profitability and growth. And the former founder then became the chairman, so they kind of swapped. Mr. Stobart's contract included a generous remuneration package, and it also made him subject to the company's staff policies, the internal policies and procedures. From August 2023, concerns were started to come to light about the company's profitability. This was mentioned in Mr. Stobart's performance reviews, but then they're also accompanied by very positive assessments of his overall performance. But profitability issues kind of continued. So actually it was from August 2022 there were concerns, and in early 2023, ongoing profitability issues led them to propose swapping roles again. So the founder became the chief executive. And in February that year, Mr. Stobart was informed that he could no longer remain in the chief executive role due to the company's lack of confidence in his ability to run the business and return it to profitability. He didn't challenge the proposal, but he did ask for a transition plan. No agreement was reached, and on the 17th of March 2023, the board of directors resolved to terminate his employment. And the termination date was the 31st of March, and Mr. Stobart was repaid the remainder of his 12 months notice in lieu. So he brought a claim for unfair dismissal, and the tribunal upheld his claim. The tribunal found that there was substantive fairness, i.e. the principal reason for the dismissal was poor performance and capability, but they found that the dismissal was procedurally unfair. So because they didn't follow a fair procedure, essentially. But of course, as we know, and this is going to become even more relevant next year, that they do also consider Polkey, i.e. what would have happened if the company had followed a fair procedure. So the tribunal looked at it and they felt that if the company had acted fairly, i.e. followed its procedures, they considered that Mr. Stobart would have been fairly dismissed a couple of months after the board meeting on the 17th of March, and certainly no later than the 31st of May. So therefore, they would have capped compensation up to the 31st of May. The company appealed the finding of procedural unfairness, and in the alternative, they said that, well, a fair dismissal could have taken place by actually the 1st of April rather than the 31st of May, because, of course, the company is trying to limit that compensation even further. On the fairness of the dismissal, the company sought to say that actually, given Mr. Stobart's seniority, it wasn't required to follow, and it wouldn't have been appropriate to follow its internal processes. And of course, they did raise concerns about profitability of the company, during performance reviews. And so these should actually, in effect, be considered to be implied warnings. Okay. So case went to the EAT to have a look at. And the EAT did make a comment that whilst warnings and opportunities to improve are generally expected before a capability dismissal, there isn't an absolute rule, and some exceptions do exist. But that's really where further procedural steps would be utterly useless, or where the inadequacy of performance is so extreme that warnings wouldn't serve a purpose. But that's really looking at kind of gross negligence cases. The EAT concluded that the tribunal hadn't imposed an absolute procedural requirement for different warnings and opportunities to improve. And the unfairness in this case wasn't really related to lack of warnings, but it arose from the company's failure to follow its own procedures and of course also failure to follow the ACAS code. So they failed to take steps to properly establish the facts. They didn't really inform Mr. Stobart of the problems very clearly, and they didn't arrange any meetings where he could put forward his own case, nor did they offer an appeal. So there was a complete lack of any form of process here, and I think that was really what was fatal. In terms of the Polkey issue, they found that the tribunal had made a mistake when looking at this, because they confined its consideration to the period after the board meeting on the 17th of March, rather than considering what would have happened if the company had actually acted fairly from the point when their concerns about his capability crystallised, which was back in February when they talked to him about stepping down from the chief executive role. And so they said that the tribunal should have considered what made the dismissal unfair and then evaluate the evidence to determine what was likely to have happened had the employer acted fairly. So essentially what they've done is they've sent the case back to the tribunal to consider that Polkey issue again. So in terms of what does it mean for us? Well, it's a stark reminder that seniority and employee seniority alone doesn't exempt us from our obligation to follow a fair procedure, especially when you've got your internal processes and of course the ACAS code applies. And in terms of Polkey, it just shows that when tribunals are looking at Polkey, it's a very fact-sensitive approach. And so again, when you're making those arguments, you want to be able to provide evidence of the likely outcome had a fair process been followed, and including like what your usual timeframes would be for such a formal process. But I think it is quite a useful reminder of how tribunals should approach Polky, because of course, from 1st of January, with the compensatory cap removed for unfair dismissal cases, that question of what a fair process would have produced is going to become a real kind of battleground, because employers are going to want to use it to try to limit the compensation. But yeah, I think it is a reminder, because I think, you know, there is sometimes a perception that if somebody's in a really, really senior position, that will, you know, performance processes, well, they just, you know, they're not relevant, they'd be futile. But actually it's a case that tells us that no, if you've got internal processes, they should still be followed in some form. So you can show that you've given the employee the opportunity to respond and improve.
I think, as you say, looking at this for next year is key, because there's been quite a lot of speculation as to whether the tribunals would be effectively developing a separate sort of line of argument around senior executives who are going to be in tribunals more and more as the compensation cap comes on. And certainly the signs at the moment are no, they won't. Everyone is going to be treated and subject to the same tests. So something to be aware of, I think.
Sorry, this is my fault. There are a couple of questions on your previous case, Matthew.
Yes, I think it's one question. What about the other unsuccessful candidate? Did they get a delay in response as well? It's an interesting question, because of course the claimant in that case used a hypothetical comparator, which was a white applicant for the job who was also rejected and also requested feedback. So I think what we can conclude from that, it's not referred to in the judgment, is that the other unsuccessful candidate didn't request feedback, so they couldn't be an actual comparator. Had they requested feedback and been subject to the same delays, etc., as Mr. Saloda, then we would have been he probably wouldn't have had a claim. At the same time, had he been provided with prompt feedback, then he would have had a better claim. So, but we just don't know. So we can only assume that feedback wasn't provided. Right, the next case, more of a news item than a case which I'm going to go through the facts of, but it's one we do need to be aware of. It's going to the Supreme Court. My understanding actually is that oral arguments have now been heard in the Supreme Court, and we're waiting the judgment, which will be sometime later in the year. But it's an unusual case and quite a significant one, as shown by the fact that it's gone to the House of Supreme Court. And it involves whistleblowing. Now, effectively, when we look at whistleblowing, when we have a protected disclosure, there are two potential claims an individual can make. First of all, they can make a claim that they have been dismissed automatically unfairly because they have blown the whistle. So automatic unfair dismissal claim under section 104, I think, of the Employment Rights Act. Alternatively, they can assert that they have been subjected to a detriment because of their protected disclosure. Now, I think what Parliament had in mind when they were looking at a detriment was that they had lost a bonus, been demoted, been subjected to some form of harassment or similar, but something in employment. But that assumption was held to be wrong in a case called Ozypov of several years ago, when the employee asserted that they had been subjected to the detriment of dismissal under section 48 of the Employment Rights Act. So the detriment itself was dismissal, and the Court of Appeal in Ozypov, Lord Justice Underhill, said that dismissal could be a detriment. Now, that was significant, and it was significant for a number of reasons. First of all, in the case of Ozypov, it actually gave the claimant a case, because by the time it got to him making his claim, he was a very senior manager within a company. By the time it got to him making the claim, the company itself had gone bust. So he had no good claim against the company, but detriment claims, not a dismissal claim under Section 104, but a detriment claim can be made against individual officers of the company or against individual employees of the company, not just the company itself. So his claim for a detriment and that detriment dismissal was made against the senior managers of that company who had the benefit of directors and officers insurance, so could pay out when the company couldn't. And that, I think, weighed quite heavily on the Court of Appeal's mind in holding that the company could be liable for dismissal as a detriment. So that was the case, and that was seen as quite a significant expansion of the whistleblowing law. Bryson, Wicked Vision and Treadwell then came before the Court of Appeal last year. And the Court of Appeal had to consider the same issue effectively, whether or not a dismissal could be a detriment under Section 48 of the Employment Rights Act, as well as an automatically unfair dismissal under Section 104. And again, if it was a detriment, then the claim could be made against individual relevant employees of that employer. And the Court of Appeal looked at this and they said two things. They said, we don't think that dismissal should be a detriment. We think dismissal should be reserved for Section 104 and should only be made against the employer, not against individual managers. And they came up with some good cogent reasons like that for that. First of all, they said, well, the wording seems to expressly exclude dismissal as being a detriment. And then secondly, they said, look, there's a general sort of principle in law that only an employer can dismiss, because that's the contract. So they said detriment, a dismissal should not be a detriment, but we have no choice but to find that a detriment can be a dismissal can be a detriment, sorry, because we are bound by the OSIPOV judgment, which is also a Court of Appeal judgment, and effectively a prior judgment of the Court of Appeal binds subsequent judgments, subsequent courts of appeal. So they have referred it through to the Supreme Court to ask this question definitively: can a dismissal be a detriment, or can a dismissal only be an unfair dismissal claim made against the employer? We don't know the answer to that. We will later in the year, but it's one to watch. But it's worthwhile just thinking about how if the Supreme Court say no, if they overturn OSIPOV and uphold what Wicked Vision, the judges in Wicked Vision and Court of Appeal would like to be decided, then it will be a significant restriction of whistleblowing law. Why do I say that? Well, it's because of what extra you get if you can assert a detriment rather than a dismissal. First of all, you can get injury to feelings compensation. You can't get that for an automatically unfair dismissal. You only get compensation for financial loss and a basic award. Secondly, the test is easier. To be able to establish liability for a detriment, you've just got to show that the protected disclosure was the reason or principal reason for that detriment, rather than showing that the protected disclosure, the dismissal, was on the grounds of having made a protected disclosure. Thirdly, it makes the litigation more complex, and that tends to be good for a claimant in this position. But fourthly, and I think this is one relevant for all of us, detriment claims very firmly put the managers on the hook. Those who are taking the decisions are the ones who can be sued, as well as the employer. So that's always something to keep in the back of your mind, that there can be personal liability of a senior manager, of a director for whistleblowing if there is a detriment claim, in the same way as there is for unlawful discrimination claims. So that's really why I wanted to raise that case, just to say that this is an area of the law in a state of flux, and we're going to get at some point soon a very significant decision coming through from the Supreme Court on whistleblowing. There's a question: is perceived whistleblowing a possible claim? That's a really interesting one, and of course sort of sits on the back of what we've discovered about discrimination and protected characteristics over the last few years, which is that a perceived a person who has a perceived protected characteristic, famous case on sexual orientation, for example, gives a claim under the Equality Act. Perceived whistleblowing a possible claim? I don't think it is. I think you've actually got to be able to make out the test for a qualifying disclosure under the Employment Rights Act.
Well, yeah, because you've got to show that the decision made by the employer is on the grounds of the whistleblowing, don't you?
And you've got to have a very we do a fair few whistleblowing claims, and one of the things which we defend a fair few whistleblowing claims. One of the things which the tribunals are always very keen to do, first of all, is to identify what the protected disclosure was, and to make sure that it complies with the myriad conditions of a qualifying disclosure. So, was there a disclosure of information, a communication of information? Did that information suggest that there had been a wrongdoing, etc., etc., etc.? So I don't think it would be enough that it was something assumed to be whistleblowing for the respondent that then turned out not to be a qualifying disclosure under the protected disclosure, rather under the legislation. It's a really interesting question, I think. So anyway, that was, like I say, more of a news article than a sort of digest of the case, but it's one to bear in mind for those of you who do face assertions of whistleblowing.
Over to me. Yeah.
To you.
Thank you. So this is a claim about continuing responsibilities in relation to permanent health insurance schemes. So obviously, PHI schemes typically require employees to remain employed by the employer to receive their benefits under the scheme, and so therefore their purpose is really very much defeated if an employer can simply remove that entitlement by dismissing the employee becomes ill. And we've got some established case law, in high court cases where an employee tells us that where an employee is covered by a PHI scheme during employment, there is an implied term that prevents their employer from dismissing them during sickness absence, except in response to repudiatory breach of conduct. And this implied term being refined a bit later on, again by another High Court case, where an employer, they find that employer can't terminate employment except for a cause other than ill health in circumstances where the employer would be deprived of PHI benefits. And dismissing in breach of this implied term gives rise to a wrongful dismissal claim. But in this case, we're not actually looking at a wrongful dismissal claim. We're looking at potential claim for unlawful deduction from wages. So AXA, they had a PHI scheme in place, and it was referred to in the employee's contract of employment, but they actually failed to enrol the employee in the PHI scheme due to an admin error. Ouch. And in the employment contract, the benefit amounted to 75% of the employee's salary, increasing by 5% each year until the employee either recovered or reached age 65. The employee had a long-term illness, and when it became clear that she wouldn't be able to return to work, she was dismissed for incapacity. But of course, no PHI payments were made because she wasn't enrolled in the scheme. The employee initially brought an unlawful deduction from wages claim against the employer in June 2013 for PHI benefits covering the period of her sickness absence up to the date of her dismissal, because of course during the period of time she was off sick, she wasn't benefiting from the scheme either. But the initial claim was from when she went off sick to dismissal. She also brought other claims as well, and as sometimes happens with the tribunal system, there was a long period of time where there's little progress made really, and one of the discrimination claims she's brought was struck out, and then she appealed, and then that ended up going to the European Human Rights, European Court of Human Rights. But I won't go down that road. But essentially, we then got to March 2022, and the employee or the claimant relooks at her claim, and she submits an application to amend her wages claim to include the PHI benefit she says was due since her dismissal for the 9 years continuation after employment had ended. And the employee argued that she benefited from an implied term preventing the employer from dismissing her while she was off sick, and that this negated her dismissal, leaving her entitlement to payments under the PHI scheme unaffected. The tribunal looked at it, and they held that, yes, the employer was contractually obliged to make the scheme payments until the date of dismissal, but they refused to allow her to amend her claim to extend the wages claim beyond her dismissal. They felt that she had little prospects of succeeding in her argument that the PHI payment should continue to be due after termination. The tribunal considered that the claim should have been more one of breach of contract, a wrongful dismissal, because they said that sums sought post-dismissal didn't properly constitute wages when you look at the definition of wages under Section 27 of the Employment Rights Act, because they weren't payments for work done. The employee, obviously given the amount of money at stake, appealed, went to the EAT, and the EAT upheld the tribunal's decision to refuse the amendment. And they also felt, well, the employment relationship is terminated, post-dismissal payments can't constitute wages for the purposes of an unlawful deduction from wages claim. She appealed again, and it went to the Court of Session. The company argued that the claim for post-dismissal PHI payments was in reality and should have been brought as a claim for breach of contract. And of course, that would have been capped at £25,000. But they also said, obviously, it was likely to be time barred at this point now. But the Court of Session disagreed when they looked at what the definition of wages can include. And they felt that PHI payments can actually be wages under the extended definition under the Employment Rights Act. It's sums payable in connection with employment or as emoluments referable to employment. And as for how the entitlement for PHI benefits could survive the dismissal, the court considered that ACTA had placed itself in the position essentially of an insurer promising to pay certain benefits for so long as she met the eligibility conditions. And since incapacity for work was one of those conditions, it made little sense if that alone allowed the payments to stop. And so they disagreed with the EAT and the ET, and they put forward basically two legal bases for saying that they were essentially, the Court of Session were right in their assessment. And they found that either it can be the case that the PHI liability was a collateral obligation under the contract, which wasn't dependent on an ongoing employment relationship, or that the dismissal was void because it breached an implied term preventing dismissal on the grounds of incapacity, and so didn't have any impact on ACTA's obligation to honour the PHI payments. So the matter is being sent back to the tribunal with a direction that the employee's amendment to her claim should be allowed. We can clearly understand why the employee was aggrieved. The employer had promised significant benefits and then, due to an error, forgot to sign her up to the scheme. And of course, that benefit's extremely valuable to her. And it's likely to be a very, very expensive error by ACTA. But it is a reminder that there is that implied, when you have PHI schemes, there is that implied term in the contract that you can't dismiss to avoid paying out in the PHI scheme. Now, obviously, you can put in express clauses in contracts. So you can put express terms in, provide, say, the entitlement is subject to acceptance of the claim by the insurer. It's limited to amounts received by the insurer. And also we put express clauses in the contracts to say that employer can still dismiss, even if that means the employer is going to, lose benefits under a PHI scheme or lose contractual sick pay. But I think this case is just a useful reminder of actually PHI benefits and how you do have to tread quite carefully in terms of the contract and what you may be responsible for even post termination.
These cases are always scary, aren't they? Just because of the amount of liability.
The value
attaches on PHI. We just see that time and time again. Would a contractual clause stating you can still dismiss if PHI is in place stand up? Yes, it will, won't it?
Yeah, it's express term.
Yeah, it's an express term of the contract, and that overrides any implied term. And we've had cases with that there, so it should just be in the contract. Okay, another issue we see quite a bit, Canalapali and Loesch, all about offer letters. And what we had in this case was the claimant applying for a job as a project manager. The claimant was based abroad. He was offered the job and he received a letter proposing a start date of the 1st of November. The offer was made, and this will be familiar to all, subject to receipt of satisfactory references and a right to work check. The offer letter didn't contain anything else about notice periods or similar at that stage, but the claimant accepted the offer. And very shortly after that, he provided both the details of his referees and the documents necessary to confirm his right to work status. The respondent then got back to him and said there would be a delay, and they were proposing a 3rd of January start date. At this point, the claimant, slightly grumpily, as you can understand, replied to say that he'd already booked his flights to the UK to start in November, and he would have no income for November and December, and what were they going to do about that? Now, they didn't really address that point. Instead, they went back to him and said, actually, we've reconsidered. They said that they hadn't been able to get internal funding for the post, and as a result, we are no longer able to offer you the contract for the position of project manager commencing on the 1st of November. We are able to consider a conditional offer based on the notice to proceed, which is the internal process. However, we understand if you no longer wish to be considered. So in essence, we're in that situation which we've seen, which is a job is offered and accepted by the individual, and then before the start date, for whatever reason, the job is off the table. So what is the liability of the employer in that situation? What was that liability here? So the claimant made an employment tribunal claim asserting a breach of contract, and the employment tribunal rejected that claim, and they rejected it by saying, well, the offer was conditional and the conditions haven't been satisfied. First of all, the job was subject to satisfactory references, and whilst the claimant had provided his referees, the employer hadn't taken up those referees at the time the job offer was the job offer was withdrawn. Secondly, it was also subject to right to work checks. And again, whilst the employee had provided the relevant documents, it hadn't been processed by the time the offer was withdrawn. So again, the employer was entitled to withdraw it. They then went further and said, well, even if that's wrong, then the employee wouldn't have been entitled to notice, because we would have implied a clause into the contract which said there was no notice during the first month of employment. And they did this based upon the fact that the employer had produced a copy of their standard terms of contract, which hadn't been provided to the claimant by that date, which said no notice during the first month of employment. So the claimant appealed, and his appeal was successful. First of all, the Employment Appeal Tribunal said, well, the claimant had complied with those conditions around references and around right to work checks as much as he could. He had done everything which he should have done. And as such, we would imply a term into the contract that said that the respondent was under an obligation not to withdraw until it had taken up the right to work and reference checks. So in essence, it wasn't enough for them just to say, well, it's conditional, and then to sit on those documents. They actually had to action them when they had received them. They were satisfactory. They would have been sufficient to confirm his employment, and therefore they could not be used as a justification for withdrawing the offer. In terms of notice, they said, no, we don't like the idea that you would imply no notice for the first month based upon a contract which the claimant hadn't seen by that date. What we will do is we will look at what reasonable notice should have been, and looking at the seniority of the role, looking at all the other factors, including the fact that this was an individual coming from abroad, reasonable notice in this case would have been 3 months. So that's what became the measure of compensation, 3 months pay rather than zero pay. So it's an interesting case, I think, because we don't often see these go to court. But it's clearly we should be making our job offers subject to both of those things. But don't think that we can just withdraw easily if the whim take us before we've got back and confirmed those to the individuals. If we did want to do that, then we should make sure our offer letter is properly worded so that it says the offer is conditional until such time as we have confirmed to you that your references are satisfactory and you have we have confirmed your right to work in the UK. It would need to be that explicit. I think the other thing is, you know, do send the contract. If you're going to be relying upon points in your standard terms and conditions, then the individual needs to have seen them. You can't just say, well, this is what would have happened. That might be some evidence of an implied term, but it clearly isn't the entirety of the implied term. So it's just a useful case which shows, you know, a situation we see quite a bit, which is when an offer is withdrawn after it's been made, but before the employee starts. And it also confirms that the measure of damages to be used in that case is going to be the notice period, rather than anything which the employee may have lost prior to employment, or an implied notice period. So that's that one.
Thank you. I'm going to do the next one quite quickly because I'm conscious of time, and it's not.
Sorry, my fault.
We both skipped. Are you just going to skip over my case completely? So this one's about this one's about restrictive covenants and in particular non-compete clause, and it just reminds us of the limits of enforceability. So, so the company does made-to-measure clothing, selling suits and shirts over in the US, and that's a global company. And Tom James UK is a subsidiary in the UK for this US company. So Mr. Potter was a personal tailor, and his role obviously does involve building, maintaining personal relationships with clients, etc., to do the made-to-measure work. And when he first joined, his contract was included relatively standard restrictive covenants, including a 6-month non-compete clause with a defined geographic scope to London. But in 2022, he entered into a new contract which significantly expanded the non-compete clause. So the non-compete was expanded to 12 months, all geographical limitations was removed, and the scope of the restricted roles was widened to prohibit competition in any capacity, regardless of the role. Mr. Potter resigned in May 2025, and the company sought to enforce the 12-month non-compete. Mr. Potter did actually offer undertakings to prevent court proceedings and said, I undertake that I won't solicit clients for staff for 12 months. But that was insufficient for the company, and there was an interim relief hearing in July 2025 where the employer sought full enforcement of the non-compete clause. The High Court dismissed the claim, and they said that the non-compete clause was unenforceable. And they looked at various aspects of it and thought, well, it went well and truly beyond what's reasonably necessary to protect legitimate business interests, in particular looking at the prohibition on working in any capacity, because it even extended to hypothetical junior roles. Excessive scope of the clause as well. So the restriction was too wide in multiple respects. The duration by 12 months, no limitation on geographical reach, and of course the role coverage, as I mentioned. And they were very critical of the one-size-fits-all approach taken by the company. So these same post-termination restrictions were applied globally across the workforce, irrespective of seniority or role, and the High Court really took issue with that. And also they found that the employer hadn't given sufficient evidence to support the need for a 12-month restriction. So a clear message to us to learn from this is, of course, that non-compete clauses need to be precise, they need to be proportionate and evidence-based, and a one-size-fits-all across the organisation isn't going to cut it. We also know that reform is on the horizon. The UK government has consulted on looking at reforming non-compete because they feel that actually they're concerned that non-compete clauses are reducing employee mobility, inhibiting growth of smaller businesses. So the proposed reforms include things like limits on duration. So, you know, it's about 6 months duration, perhaps. Variable limits based on company size, perhaps a complete ban on non-competes, and also maybe looking at salary thresholds. And if you're below a certain salary, then you shouldn't be subject to a non-compete. So, but we're of course waiting for the outcome of that consultation and what they're going to do next. But it is just a useful reminder about the importance of drafting your restrictive covenants carefully.
Yeah, bizarre that they should have taken it that far, given the fact that it was just a uniform off the peg restrictive covenant. It really is an old one, but it's a really good reminder.
Yeah.
Right, very quick case on redundancy. Lots of cases have come through on the back of COVID about redundancy because of all the redundancies that were made. So we've actually got some quite developed law, and I think some tightening up of rules around redundancy. Now, in this case, we had the claimant, Mr. Kennedy, who was employed by Hendy Group, which is a large car dealership, multi-dealership. He had been employed for 30 years, and by the time he was made redundant, he was a trainer within the training academy, although he had lots of roles before that, including having managed various dealerships and various parts of the business. So he's very well qualified. He accepted there was a redundancy, but he wanted to stay and he wanted an alternative role. And you'll remember we've got the Holy Trinity in terms of redundancy and redundancy due process. We want to see that there's a genuine selection for redundancy. We want to see that there is proper consultation around that redundancy. And then we want to see that there has been proper consideration of alternative vacancies. And it is this area which let the respondent down and led to the finding of unfair dismissal, which was upheld on appeal. And it's salutary, I think, for those of us who deal with redundancies in HR teams, because effectively what the tribunal and the EAT said in this case was that the response to the redundancy from the HR team was wholly inadequate. What they did was they pointed the claimant towards their intranet, which had details of vacancies, and did little more than that. There were many vacancies on that, but all the vacancies were then, sort of managed and decisions taken by individual managers at each of the dealerships or within each of the functions. Some of these rejected Mr. Kennedy without interviewing him. Some of them interviewed him but decided they preferred someone better, often an external candidate. And so Mr. Kennedy ended up not getting a job, and he ended up making an unfair dismissal claim for that failure. And again, the tribunal was quite scathing. The Employment Appeal Tribunal was quite scathing of the fact that HR had done so little. The tribunal in particular suggested what the employer should have done in this case. And again, that's quite relevant. They should have assisted him in applying for vacancies. They should have communicated with the hiring managers about the fact that this was an employee at risk of redundancy. They should have looked at providing him with training to fill in the specific gaps in his knowledge, if there was perceived to be specific gaps, and they should have advocated for him with those managers prior to any decisions being taken about hiring for those jobs. It was not enough just to point him in the direction of that intranet and then getting on with it. So it's another case where the employer also sought to argue that there should have been a POLKI reduction, and there wasn't. And again, that was something that was appealed, and the EAT again gave short shrift. They said the approach taken by the employer was so inadequate that it was wholly reasonable to not make any POLKI reduction. It was wholly reasonable to assume that had they done everything properly, then the claimant would have been in another job. So again, worthwhile just looking a number of cases in this from this time about redundancy, but there is an obligation to ensure that there is a facilitation of job seeking and applications for an individual who is at risk of redundancy, particularly in large organisations. Vanessa.
Over to me. Yeah. Oh gosh, I was going to try and do this quickly, but I can't. So if anybody needs to go, then do. But this is a really important case, particularly for those that of you that do lots of TUPE and insourcing. So the claimants were a group of 80 cleaners of BAME backgrounds, and they're part of a group of staff who are employed by a contractor to provide cleaning services for Great Ormond Street Hospital. They were insourced by the hospital from the 1st of August 2021. The contractor, the hospital employed its non-medical staff on an agenda for change terms, which is the NHS pay-wide structure. Prior to the insourcing, the contractor employed the claimants on the London living wage. Now, this was at Great Ormond Street Hospital's request, because actually the London living wage was actually a bit higher than what the contractors would normally pay their employees. But of course, the London living wage is still less than the pay rate for the agenda for change. So the staff transferred, and then the staff who transferred to Great Ormond Street Hospital, they remained on the contractor's terms and conditions, because of course you TUPE over on existing terms and conditions. And this was pending a consultation about harmonisation. So ultimately, that harmonisation did result in many staff being moved over to the agenda for change rates. But the claimants brought claims for indirect race discrimination on 2 grounds. One is that pre-transfer, the hospital had failed to require the contractor to offer its staff the higher agenda for change pay rates. And secondly, post-transfer, the hospital had failed to offer the higher pay rates from day one of the TUPE transfer. So the tribunal concluded that both claims should fail, because they felt that it couldn't be established that the hospital had applied a PCP to the claimants, because this is an indirect discrimination claim. As a tribunal, they felt they hadn't been provided with evidence relating to racial composition and contractual terms of other contractors to the trust, because they were looking at other contractors. Both the claimants and the respondent appealed, and it went to the EAT, and the EAT looked at pre-transfer and then they looked at post-transfer. In terms of pre-transfer, they agreed with the tribunal's decision. They said there's a line of authorities that doesn't allow, which tells us that the Equality Act doesn't allow discrimination claims to be brought by contracted staff against a client, which relates to remuneration payable under the worker's contract of employment with the contractor. So essentially, the claimants can't claim against the hospital in relation to the pay that was actually payable by the contractor. That's a stretch too far. But in terms of post-transfer, of course, following the transfer, the claimants became employees of the hospital. And at that point, under TUPE, once transfer takes place, the employer is responsible for those terms and conditions it inherits. And so in light of this, and the fact that the claimants weren't immediately moved to the higher pay rates, the EAT felt that, yes, the claimants were treated differently from other employees employed by the hospital. And then they went on to consider the PCPs put forward by the claimant. And they upheld one, which was that they found there was a PCP by the hospital that made an employee's ability to receive the agenda for pay and other benefits for working as a cleaner dependent on not having been transferred from an outsourced contracted employer. So essentially, they found that because this PCP was dependent upon being an employed cleaner, and the comparison was between cleaners employed by the hospital and cleaners employed by contractors, the ET did have that information. The ET did make findings of fact that the claimants were in a group that were disproportionately disadvantaged ethnic minority staff because of the makeup of the staff that transferred, and there wasn't an objective justification for the PCP. So, and it was also important that the transferring workers had in their contracts of employment, under their employment with the contractor, there was the express clause that permitted the employer to make reasonable contractual changes. And so the AT found that the indirect discrimination claim should succeed. This is notable because this is a finding that there should have been day one harmonisation by the hospital. And in relation to potential indirect discrimination. So what this means is when you're carrying out your due diligence exercise, you're going to have to go a bit further if the incoming employees, if their pay is going to be lower than your existing workforce. What this case tells us is that you need to kind of delve deeper into that, into the demographics. Is this particular a group with the protected characteristic, which could lead to a potential indirect discrimination claim. And of course, that kind of due diligence goes over and above the employee liability information as well. So when you're kind of entering into your contract, you're going to want enhanced information built in that you're going to require from the contractor. But I believe this is kind of like the first case really I've seen where there's a discrimination claim brought in terms of cheaping across, because I think the understanding always was, well, that's our justification, it's because they've cheapied over on existing terms.
Yeah, it needs a lot of thought, this one, doesn't it? And I think that idea that you've got to harmonise from day one also puts a further burden on a transferee, which is making sure you've got all your ducks in a row and you're ready to go from the moment you take on the new provision.
Yeah, and all the consultation as well around that.
Yeah. There's a few questions on this. Sorry, Oliver, I'll come back to you separately about the draft wording. What does this mean for other TUPE transfers if they had no protected characteristics? Well, you've really got to harmonise the whole group, haven't you? Yeah. Rather than just those with the characteristics. But it's the fact that you've got a group who are disproportionately affected that leads to that decisions. Yeah. I get the point that there are some real issues here around pay and the effect that this would have, and it is a judgment which requires, I think, some consideration for anyone who is taking on contracts, particularly where the margins are tight. You've got to be really sure about what liability you're getting into. Yeah, absolutely. And you've got to understand the cost of taking that on, haven't you? Yeah, absolutely. Right, I will finish very quickly by looking at the HRC Code of Practice, HRC Services Code of Practice. So this isn't about employment, but it really gives us some good hints of where the EHRC is going about this. You'll remember the For Women Scotland case last year before the Supreme Court, which said that for Equality Act purposes, sex means biological sex. It does not mean the gender of choice for someone who has a gender reassignment certificate. It is biological sex that matters, and led to and continues to lead to a number of controversies. This was a very controversial code. It was subject to judicial review a while ago. It was laid before Parliament on the 21st of May. As of the 30th of June, the 40-day period for which it has to sit before Parliament expired, and my understanding is it's going to become a formal code over the next few months, and then it becomes highly influential on other decisions. There is a employment code of practice as well, and we will no doubt see some amendments to that as a result of the For Women Scotland case in the coming months. Now, the big issue for the provision of services is all about single-sex spaces and how you manage single-sex spaces in light of the code. And as we know, many organisations had looked at single-sex spaces and had applied before For Women Scotland had applied an interpretation in accordance with the old EHRC code, which said a single-sex space is for those who are born, for those with a biological sex, and those who chose a gender of choice. For Women Scotland turned that and said, no, it's just biological sex that matters. What the what the code does is just start to analyze that. And where it's really caused consternation is that it's trying to square a couple of circles. First of all, it has to say that single sex spaces are for those only of one biological sex, and that's what it says. There are narrow exceptions for that, of course. It is changing rooms, it is services where there is a real need to have a particular sex-specific service. And if you were to bring in people of a different biological sex into that space, it stops it being a single sex space and therefore falls out of the Equality Act protections. So then you're open to discrimination on that grounds. How it tries to square that with trans rights is by saying you've got to do this. You've got to provide a single biological sex space. But if you are doing that, then you've got to try to be proportionate and make alternative facilities available for transgender people if they are now excluded from a particular space or service because of their biological sex. So effectively what it does is give us a lot of examples of how you might go about trying to mitigate the effects of for women in Scotland. You could keep your biological sex spaces intact, but provide an alternative facility wherever possible for trans people. The obvious example given is toilets. Toilets, changing rooms need to be single sex, single biological sex. You can't exclude that. You can't change that. But there is now quite an obligation on organisations to try to provide an alternative facility, whether that is a unisex disabled toilet access or baby changing access type facility that transgender individuals can use is the obvious one. So, and that definitely is where the law is going on this area. So we raise it because whilst it's not directly relevant to employers at this stage, it shows very much where the law around facilities is going, and I think the kind of guidance we're going to get over the next year or so. But for those of you who are scratching your heads about this and are thinking that you've got issues with this, or you've got issues coming down the line, it's either with customers or with employees, I think it's worth having a look at the code. It's worth having a look at section 10 of the code in particular, which gives some really good clear examples of what to do in this area. So that's the EHR services code, and it is worth looking at because it is going to become law very shortly. So we've overrun. So apologies for everyone for overrunning, but then I think we always overrun, don't we?
I think it's probably not as much. So I take
probably
it back.
Not as much as this, but yeah.
No, we should have maybe done 8 cases, not 10. Well, no, there's so much
yes,
back cases,
no,
isn't
we
it?
ended up with 9, but there we are. Just putting it together. I think if there was a theme for today, it's documentation.
Yeah, I agree.
And it's getting your documentation right, and it's following your process. You know, if you get those things right, then you're 90% there with defending a claim. If you get them wrong, then you're not.
Yeah.
And don't be silly and try and enforce covenants when you really should know better. That'll be the motto.
Well, yeah, and that was very expensive. Would have been a very expensive mistake, wouldn't it?
It would have been an extremely expensive mistake.
Going to the High Court.
So thank you all for bearing with us. Thank you for your questions. Yes, we can provide slides. I'm sure we can do that. Steve, no doubt we'll do that, and we'll be back. For those of you who are in the hub, we'll be back with a webinar in a couple of weeks, I think, on ERA related matters, and we will no doubt be back with further case law updates at some point in the reasonably near future. So thank you very much.
Lovely. Thank you very much,
Bye-bye.
everybody.